Feel free to continue eating. We're going to start talking about ethics. We've got two new presenters. We have Lupe and Amy. I'm going to go ahead and have them introduce themselves when they get up here. But we're going to spend an hour on ethics, and hopefully we'll get lots of questions. We want to generate a lot of interaction with you guys in the audience. I'm sure you have lots of questions. And I was just talking to Amy. I realized I didn't introduce myself. I know a lot of you, but my name is Nancy Thamert. I actually work over at the Supreme Court across the road with the Administrative Office of the Court and provide direct support for the Guardianship and Conservatorship Committee. So this is very close to my heart, and I'm very happy that we were able to bring this amazing training to Boise. So with that, I'll bring it over to Amy.
So my name is Amy Cunningham. I'm the legal director for Disability Rights Idaho. I am an attorney. I do a lot of supervision now, but I am an attorney, and I'm here to talk about what at least all of the attorneys want is that ethics piece for that ethics credit. So what I'm going to be talking about are the Idaho Rules of Professional Conduct. Judge is going to give a quick comment on a couple of judicial canons, and then Guadalupe with the Department of Health and Welfare, she's going to be talking on the Social Workers Code of Ethics. I think after you hear our presentations, you'll notice that really all of the codes of ethics are saying the same thing. You know, even if you're not a social worker, a lawyer, or a judge, if you're a nurse, a physician, and if you're just, a United States citizen, what we're about is rights and protecting rights and having individuals to be able to exercise their rights and to be the best that they can be. And that's really what the Code of Ethics, I believe, talks about and strives to achieve. So my goal in this is that I provoke you all to think about things and think about what's going on in your cases and how the ethics rules may apply or may give you a different perspective on what you have been doing and how you can proceed in the future. So the first thing that I would like all of us to remember is there is a presumption of capacity. There's a presumption that everyone can make decisions. In a guardianship, the burden of proof is on the petitioner to show that there is not capacity, maybe not full capacity, or maybe there's limited capacity, but that burden is on the petitioner. And as both Jonathan and Judge said, there has been no carved out exceptions for people with disabilities that they don't get to exercise due process or they don't get to have due process. And you will see in the Idaho Rules of Professional Conduct that individuals with disabilities have the same status as individuals who don't have disabilities. They're all clients. And so I'm going to start with our first slide. This is the preamble for the Idaho Rules of Professional Conduct, which says a lawyer is a representative of clients. And as a representative, a lawyer informs a client about their legal rights and their obligations. A lawyer zealously asserts a client's position under the rules of the adversary system, and a lawyer seeks a result advantageous to the client but consistent with the requirements of honest dealings with others. So in that, when you are a client, this is what you can expect from your attorney under the rules. And I didn't list out all the rules, I just picked out a few because there's many rules. The lawyers to respect the client's wishes or purposes of the representation, work with diligence, communicate with the client, keep all information and communications confidential, and provide representation free from conflict. So but you have a client and they may have some diminished capacity, but they're still a client. So now what do you do? Well, the rules also guide the attorney that the lawyer shall, as far as reasonably possible, maintain a normal client-lawyer relationship with the client. So what does a normal client-lawyer relationship mean? We again can go back to our rules. In comment number 1, the normal client-lawyer relationship, it is based on the assumption that a client, when properly advised and assisted, is capable of making decisions. The comment goes on to say that a severely incapacitated person may not have the power to make binding legal decisions. However, a client with diminished capacity often has the ability to understand, deliberate upon, and reach conclusions about matters that are affecting them. Comment 2 explains that while maintaining this normal client-lawyer relationship, you are to treat the client with attention and with respect. Rule 1.4 is a lawyer's responsibility regarding communication. So lawyers are required to, so this tells us what we need to communicate and how we need to communicate it. So first, what we need to communicate with our clients is we need to communicate with them any decision or circumstance. Wait, am I on that? I clicked, yeah. We need to communicate with our client any decisions that are made regarding the representation. We need to reasonably consult with the client about the means of how we're going to achieve the client's objectives and purpose of the representation. We need to keep our clients reasonably informed about our representation, and we need to consult with our client about any relevant limitation on the lawyer's conduct when the lawyer knows that the client expects assistance not permitted by the rules of professional conduct or other law. And I'm going to come back to that little section there. But B, I think, is the most important part of this rule, and it says that a lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. So what this means is, just like Jonathan said, when we go to the doctor and we're about ready to get a surgery, and the doctor is using all of these terms that we don't understand, and then we say to our doctor, okay, bring it down. We have that same responsibility as lawyers. We need to bring it down. We're not talking in the shalls and the therefores and the wherefores. We break it down, and that's what we're required to do under our ethical rules. So, and this rule applies to all of our clients. Now, the rule provides, when we go back to 1.14, when we have a client that we think may have diminished capacity, it provides us some guidance on how we can achieve the communication requirements. And it allows, if a client would like to have a family member or someone else participate in the conversation to help in that explanation, our rule allows for that. And on top of that, it specifically states that your attorney-client privilege has not been waived, which is big. So the client is still protected, you're protected, and this allows you to be able to explain to your client in that conversation that you're having in your office what's going on. So how, as an attorney, do we evaluate and determine the diminished capacity? Well, our rule in comment 6 provides a guidance and gives us factors, specific factors to consider when we're trying to make a determination if our client has diminished capacity and the extent of the diminished capacity for which we may need to take protective action. But I want to say on this is that this is nothing new for attorneys. We're always evaluating different aspects of our cases, different people that we are dealing with. For example, we are always evaluating and assessing the quality of an expert that we may call. We may evaluate and assess our client's ability to provide testimony, which may or may not have anything to do with capacity. We're also evaluating in cases involving children, a child's ability to be able to communicate with the court or to communicate with an evaluator. So when we have a client that may or may not have diminished capacity, this is nothing new for a lawyer. We are to apply our well-honed evaluation skills. So I want to return back to the slide of what a client can expect, because these are some things that I want you to consider. So under Rule 1.2, we as a lawyer are supposed to respect the client's wishes or the purposes of the representation. So how does a client arrive at the purpose of the representation? Well, they come to us and they need to be advised of their rights and the risks and what is going on in the representation. Specifically, in a guardianship, I'd like you to consider the things to be shared with the client, whether your client is somebody who wants to be a guardian or whether your client is somebody who's proposed to be underneath the guardianship. So in a guardianship, there is, and I've included in your packet, a list of rights that are at risk of being removed from someone. Well, if you are representing either a guardian or somebody who may be underneath this guardianship, they need to know what's at risk here. They need to know what rights are at risk of being removed if a full guardianship is imposed. And there needs to be a discussion about, well, what rights can a person exercise, what rights maybe they need help with, and if there are any rights that they really cannot exercise. Also, if you're representing someone who is a guardian or who wants to become a guardian, they need to know that they're going to have to fill out a criminal background check, that they're going to have to file reports every year with the court, and that's going to cost $35. And if they're a conservator also, it's another report, another $35. And if this is a younger person and the guardianship is going to last for many, many years, this is something that's going to go on for many, many, many years. And if you don't file those reports, you're at risk of being called in by Judge and saying,
we use persuasion more than coercion.
Why are you not filing your report? They also need to be told about alternatives. You have alternatives. Because once an individual is told about all of the rights that are subject to be lost, they might have had a different understanding of what guardianship means. And you want your client to be able to make an informed decision about what is the goal and the purpose of the representation. So these items need to be communicated with your client. And then in consideration of the Rogers case that we just spoke about, where the court said the statutes, and I encourage everyone to read that decision, because the court's analysis is that the statutes first require least restrictive guardianships and limited guardianships. And the statutes are pretty clear in multiple different spots that it starts with nothing, and then you go to limited, and then you use the full as a last resort. And so and the consequence in that the Rogers case explained was that if there is a full guardianship imposed, then what the Supreme Court has presumed is that the court has been presented with evidence and has made a determination that an alternative will not suffice, a limited will not suffice, and we need to have a full, and therefore this person, there's been a legal judicial determination that this person has no capacity to make any decisions at all. So going back to the communication ethical rule, I'd like you, this is food for thought, to think about the limitation in 1.45, which says consult with the client about any relevant limitation on the lawyer's conduct when the lawyer knows that the client expects assistance not permitted by the rules of professional conduct or other law. And so if you're an attorney and you're questioning whether or not the person that your client wants to become a guardian over if they're asking for a full guardianship and you're questioning about, well, do they really have no capacity to make any decisions at all? Think about your responsibility under 1.4 to communicate with them about the Rogers case and what it means and whether or not you can proceed with that particular wish, or maybe if you should look at some alternatives. When you are representing somebody who is, oh yes.
Amy, I'm curious, I'm not an attorney.
Yeah.
Do attorneys consider, when working with people with intellectual and developmental disabilities, if I have an alternative way of communicating, if I'm nonverbal, if I use behavior as communication, is that all considered as part of the communication, and attorneys have that information when they think about all the different ways that people with intellectual and developmental disabilities are communicating their
Well, that's the piece
or ideas or
that I'm going to get to when I talk about working with diligence. Okay. So when you're representing somebody who is proposed to be under a guardianship, they need to know what rights are at risk that they're going to potentially lose. They also need to know what the alternatives are and if they would like you to pursue an alternative. And then now I'm going to talk a little bit about gun rights, the Second Amendment, which is in this state, it's a pretty big right. A lot of people like to hunt. And what we discovered is that there is a federal law. It's called the Federal Gun Control Act of, ready for this, 1968. And it is a federal criminal law. And it prohibits, it makes it unlawful for certain persons to ship, transport, receive, or possess firearms or ammunition, including, and this is the words in the statute, persons who have been adjudicated as mental defective or have been committed to a mental institution. And mental defective means that they've either been committed because they're a danger to themselves or others, but it also includes guardianship. And this is a Class C felony. And not only does it apply to someone who has been under a guardianship or has been committed, but it also applies and makes it unlawful for any person to sell or otherwise dispose of any firearm or ammunition to any person knowing or having reasonable cause to believe that such person has been adjudicated as mentally defective. So if you're a guardian and you want to take your son or your daughter hunting and you're their guardian, under this particular statute, you could be prosecuted as a federal Class C felony. And this legal disability, being declared a mentally defective, even if you have the guardianship terminated, or if you've no longer been committed, you are still under this label of being mentally defective, unless and until you go back to state court in front of a judge, and a judge makes a determination that you are no longer meeting this federal definition of mentally defective. So that's a pretty big right. And then here's the kicker. The U.S. Attorney's Office in Idaho did prosecute somebody underneath this statute who had previously been committed and then was found in possession of a firearm. And Judge Windmill said there's no ignorance of the law, because the person's defense was, nobody told me. And he's like, well, that's too bad. So sad. So something to consider advising your clients on. The next rule that I wanted to talk about is the diligence rule. So we're required to work with diligence. So what does that mean? So when I'm in the past, in a past life, I did some criminal law, criminal defense law, and involving some injuries, specifically spiral fractures. Well, spiral fracture? Like what is a spiral fracture? So what did I have to do to be able to provide good defense for my client? I had to go to the library. And I went to the library, I did my research on what in the heck is a spiral fracture? Well, how does it occur? What are they talking about? Why is this such a bad thing? And then I wanted to make sure that I was interpreting this right and understanding what I was reading. And fortunately, my father was a physician, so I called up my dad and I said, can you give me a free consult? Tell me about these spiral fractures. What are they? How do they occur? Is it always look like this? But I did my research so that I could know how to cross-examine when I was in court. I knew how to cross-examine the professionals that testified. I knew how to cross-examine the police officers that testified. And we as lawyers, we do the same thing in product liability cases. We go and we have to research in some of the engineering techniques of whatever device may have become defective, but we do our research in that area. So for consideration, in a guardianship area, when you're representing somebody who has a disability, do some research on what is the disability, what are the limitations, what does it mean, is it permanent, is it temporary? Also research into what is the support systems, what is the service system that's out there, because the standards in guardianship are, can the person maintain their financial situation and provide for themselves in the community. Well, there is a pretty extensive service system out there, especially for adults with developmental disabilities. And those service systems have information that can help you. either way, if you are representing somebody who wants to be a guardian, or if you're representing somebody who's potentially going to be under a guardianship. These are resources for you to tap into to meet your ethical duty to work with diligence. And then that would also require what Christine was bringing up, is that people communicate in different ways. And just because somebody isn't communicating the way we're normally communicate with others doesn't mean that they're not communicating and that they can't communicate. So some research in that area too can be very helpful to help you comply with your ethical responsibility. And then the last one that I want to bring up for consideration is what happens if you're appointed as the attorney for the person that's proposed to be under a guardianship and their GAL. So when you're a GAL, your responsibility is to report to the court what is in the best interest of that individual. When you represent a client, you are to put forth the client's wishes and purpose for the representation. So what happens if you are representing an individual, they don't want the guardianship, and you're the GAL, and you're not sure, maybe they need a guardianship. So you're torn. Who are you loyal to? Are you loyal to the court and telling them what your opinion is? Or are you loyal to your client? And when you're sitting down in the office with the individual, as we all do, is we say, okay, we've got the attorney-client, I'm your attorney. Everything that you tell me is going to be confidential, and I'm not going to be able to share that unless you give me permission. And then you include in your GAL report statements that the individual told you. So consider whether or not, if you are put in that position of being a GAL/attorney for the individual, can you meet your ethical obligations? Can you provide this representation free from conflict? Where does your duty lie, to the client or to the court? And then on a practical note, the way that I have handled that and how I have the attorneys in my office handle that is we tell the judge up front, we're like, look, we're representing this person, period. We are not going to be the GAL. We are not going to be filing a report. If you feel like you need a GAL in the case, then you're going to have to appoint someone else, because we're not going to provide that role. We cannot ethically do that. And in the DD Act, the 66 Chapter 400, there is no provision for a GAL. So we also make that argument, is that the statute does not allow for a GAL. However, under Title 15, it does. And when I've made this argument to the court, they've never said, oh no, Amy, you're going to do both. They're just like, okay, I believe that the person's going to be provided good representation, and that's what the court is really worried about and wants to focus on. But if you do run into a scenario, or if you are worried about that, then I would encourage you to file a motion with the court and say, hey, I want you to explain to me what exactly is my role and how am I to reconcile that with the Idaho Rules of Professional Conduct. Yes.
I'm really sorry, and you can tell me to quit asking questions, but
No, please.
why would a person be put in that position to have to be both? I don't understand that.
Because the statute is, the probate code statute, Title 15, has some language that says an individual gets an attorney, guardian an attorney with the powers of a guardian ad litem. And then when you go over to the guardian ad litem statute, there's a separate guardian ad litem statute. It requires that you provide a report to the court about what's in the best interest in this particular situation.
There's also a form problem, Judge, because the form that they use to appoint says attorney GAL, and they only putting one name on there. They're not crossing one off or explaining.
Yep.
Well, we've got words where it says, assigns an attorney with the powers, like you said, as a guardian ad litem, and our statute doesn't even allow it. But
Yeah.
it's done.
So any other questions on the Idaho Rules of Professional Conduct piece?
I love Judge. I want to steal him for my county. Not that I don't like my judges. Don't get that out there. So my name is Lupe Ayala, or I'm Lupe, and I am the social worker with the Department of Health and Welfare. I serve as one of the social workers on the Guardianship Evaluation Committee. When an individual has a developmental disability diagnosis, it has to be referred for evaluation by our committee. And so I am one of the social workers. I will point out the other two so that you can see their faces. If you have questions and see them, you can ask them questions. Jackie Graven and Diane Stevens. And then our supervisor is Amanda DeYoung there. So you guys have faces now if you have questions. Before I forget, I want to let you guys know, and I feel like I'm going to talk fast, only because we're running out of time, and I want to give you guys time to answer questions with these lovely people. If you go with the Department of Health and Welfare under developmental disabilities, there is a website. Our website is on there, and there is tons of resources, and it refers you to other resources on supported decision making. And so I encourage you guys to go and look at those and see what's out there also on our website. Okay, so now I will stick. Is that right? Okay. So I'm sure that we are no different as social workers than the attorneys and guardian ad litems, that you all have your code of ethics that you follow, and we social workers are no different. We have a huge page that we have to follow. I think our most important one is the primary mission of the social work profession is to enhance human well-being and help meet the basic human needs of all people, with particular attention to the needs and empowerment of people who are vulnerable, oppressed, and living in poverty. And I think that, to me, it says it right there, that we as social workers, we have that responsibility, that our mission, primary mission, it really is to enhance human well-being. It's to help them. It's to empower them. And so I can't tell you how excited I am to be part of this panel and to have been part of supported decision making, because I think it speaks to our obligation. And I think that we have to remind ourselves as social workers that we have bosses, and our bosses have different expectations of us, and sometimes that they may conflict a little bit about what the boss is asking us to do with what our ethical obligation is. And if we all value our license, we always have to fall back really on what the code of ethics tells us to do. And so when I have a family that comes to me and they're saying that they want a full guardianship, I have to remember that my primary goal, even though that petitioner is paying and technically can be viewed as, somebody's client and they're the one that's paying for it, they're not my client. And my ethical obligation says that I have to look at this individual and I have to make sure that I'm helping to enhance. So is this guardianship helping me fulfill my obligation? And so keeping that in mind, I think that as social workers, especially us in the committee, I think we've been put in a position where, I don't want to say this is new, because as they've said, this has been around for years, but it feels like it's new. We're put in a position where we're kind of butting heads a little bit with the attorneys that are being hired to do this, and the judges that are still, adapting to these changes. We're in a position where we're having to say, hey, no, let's look at all these other things before we look at that. And again, this empowers us to be able to say, I have a responsibility to do that. The social workers have set of core values: service, social justice, dignity and worth of the person, importance of human relationships, integrity, and competence. And so I think, again, those all speak to our obligation of that everything that we are doing now in trying to ensure that these individuals are empowered goes to meeting what our core values are. I think the main one of those is dignity and worth of the person. Social workers respect the inherent dignity and worth of a person. So again, remembering that that individual is no different than any other individual, except that maybe they in my case, they have a developmental disability. You know, I don't work with incapacitated statute, but I am sure it all applies the same in that everybody's the same. We still have a responsibility to them, and remembering that dignity and worth of the person is keeping that in mind when we are working with them. The standards, ethical responsibility to clients, 101 is self-determination. Social workers respect and promote the right of clients to self-determination and assist clients in their efforts to identify and clarify their goals. That is so well said. That says, supported decision-making to me. We respect and we promote and we assist. And that is, again, going back to when we are speaking to an attorney and we're speaking to these parents or these petitioners that want to apply for guardianship, are we keeping to our ethical standards? Are we, even though it's that person that has approached us, are we fulfilling our mission to help these individuals and helping them to promote their self-determination and their rights? I think as a little thing that I find is that we get in such a hurry. Our society sometimes gets in such a hurry. I'm the doctor. I just want you to sign this. I just want to tell you what this is and sign it and get done with. And the same thing with schools. I don't want to break things down. I just want to tell you what the form says and signs it. And I think that's where we get in trouble a lot of the times, that we don't have the patience to break it down and let them understand it. If you guys review our statute for 400-6404, it says, does the individual have a rudimentary understanding of whatever it is that's being discussed? Rudimentary. It's a basic understanding, just like anybody else. And they've mentioned it before. I don't have a rudimentary understanding of what is being done in my taxes or what my doctor is saying to me or what my mechanic says to me. I don't. And they'll break it down to me and just say, your brakes are done. And I'm like, oh, okay, it's the brakes. I get it. The brakes is what stops my car. I get that. So again, it becomes hard for people that they think that because they have a developmental disabilities, for some reason that breaking down becomes difficult for them or troublesome for some reason. And again, as social workers, we're there to promote that. And so reminding these individuals that things do need to be broken down and things do need to be said different for them, because again, we have that obligation to them. So, if you'll look at our statute, if you guys are bored, or excuse me, our ethics, our board, each of the ethical responsibilities that we have speak to our responsibility to helping individuals be able to live their own life just as we want to live our own life. And that we have as hard as it may be when we butt heads with the attorneys and the judges, that we have an ethical responsibility to social justice, and that means coming to these little workshops and then taking it back and getting ready to butt heads with your attorneys or your doctors and saying that we have an ethical obligation to allow them to live their lives just as we want to live ours. So, hope that's it. Sorry. Yay.
Of course, now you fully appreciated why we wanted social workers here. I mean, really, they're the ground troops on this effort, and that was really well put. So thank you. I just have a couple of things to say about the rules of judicial conduct. They're binding on judges, of course. Standards for judges are incredibly high, as they should be, because respecting the rules of professional conduct or judicial conduct and also professional conduct is what gives the public the faith that they have an independent, impartial judiciary. It gives people the faith that they can rely on decisions by an impartial court, and that lawyers are not operating completely out of self-interest, that judges do not operate out of self-interest, because when it really comes down to it, it's not about us. It's about the larger system of justice that we're here to serve. I mean, when people say, for example, and I'm not suggesting there's something wrong with this, but it always bothered me as a lawyer, and it bothers me as a judge when judges say, my court. And I always get into this mindset, and I think the mindset is really important, that it's not my court, not my court. It's the people's court. And we're here to serve. We've been entrusted with a certain responsibility. So I think that's the right headspace to get in whenever you walk into court as a lawyer or a judge. So part of that encourages and supports the rule of law, which is central to our society and the operation of justice. Nobody's above the law. And Rule 1.1 of the Idaho Code of Judicial Conduct requires judges to comply with the law. I mean, this is how simple it is. A judge shall comply with the law. How complicated is that? Well, sometimes it's hard to interpret the law, and that's what judges do too. So that's a big one, and I talked about that earlier. I mean, what we're talking about is not some major change in the law. We're just talking about complying with the law, and supported decision-making helps us comply with the law. Rule 2.6, I think, is the other most important aspect of the Idaho Code of Judicial Conduct in this area, and maybe most areas, is ensuring the right to be heard. That's all about procedural fairness. When people know that they've been heard, they've been given the opportunity to be heard, they feel that the process was more just. They feel more like complying with the order of the court if they felt like they had an opportunity to explain. I think the flip side of the opportunity to be heard is the obligation of the court to explain to people what is the basis for the decision, so that people understand when they leave court why that decision was made. So I think that's a big part of judicial responsibility. So that's really all I'm going to say about the rules of judicial conduct. Pretty straightforward. I do want to come back to one thing, and I appreciated everything that Amy said about the rules of professional conduct for lawyers. But I just have to, I love the preamble, okay? And I love the first sentence of the preamble, and I think it's applicable to what we're talking about, because lawyers don't just have responsibilities to their client. And this is the language, and I just think that, lawyers ought to read this at least once a month, just to remind themselves, because a lawyer, as a member of the legal profession, it's a profession, is a representative of clients, an officer of the legal system, and a public citizen having special responsibility for the quality of justice. See, I can barely even read it. It's a big deal. It is a big responsibility. And we all need to honor that. The last thing I want to say is this whole issue, and I think it needs to be addressed, about the confusion of the responsibilities of a GAL and the responsibilities of a lawyer. It puts the lawyer in an absolutely unacceptable conflict of interest, a legal conflict of interest. And the way I've sort of navigated the statute, and we're told this, I mean, in terms of interpretation of statutes in the case law, it tells us, well, read it narrowly. Give it the the meaning that the plain language requires. And the actual language that is concerning to people is that the court, and so this is appointment of an attorney, and so this is unless the alleged incapacitated person has counsel of his or her own choice, and I added or her, the court shall appoint an attorney to represent him or her in the proceeding. And this is the language. It's an additional clause that says, who shall have the powers and duties of a guardian ad litem. And judges view this differently. I have resolved, and I think it's inadequate, but the potential conflict by just reading that as you have the ethical responsibilities of a lawyer to represent the client, but you have the powers that are vested in the statute on guardian ad litem. And what that statute does is it gives you access to a lot of information that you need to properly represent the client. Not all judges look at it that way. So, but Amy's absolutely right. I mean, I think it's completely appropriate for you to clarify with the court what you think your role is if you're appointed to be a guardian ad litem as a lawyer. Because this statute does not trump your ethical responsibilities to clarify what those are. And so you just can't do both. I mean, it's an inherent conflict. That's my opinion. Maybe not everybody shares that opinion. There's an excellent article. This was written a long time ago, 2002, by Joan Sullivan. This is in volume 31 of the Stetson Law Review, 687. It's a 2002 article called Role of the Attorney for the Alleged Incapacitated Person. It's really a great exploration of this exact problem, which has been out there for a long time. So that's really all I have to say about that. I'll turn it back over to Jonathan.